Welcome to CLESTalk, Law for Sustainable Cities, a podcast that focuses on all things cities, law, and environmental sustainability. In this podcast, we venture into different urban and environmental legal themes, feature special guests, and also host our own CLES researchers. As you know, CLES forms part of the South African Researcher Initiative of the National Research Foundation of South Africa and operates under the Faculty of Law at the Northwest University. My name is Lidile Sekwakwa. I am a PhD researcher at CLES and your host for this session. In each episode, we unpack the legal tools shaping sustainable urban development, and today's topic is one that is both urgent and complex, which is criminal prosecutions for environmental impact and pollution-related transgressions in South Africa. With environmental degradation worsening in many parts of South Africa and water pollution being one of the most visible and dangerous forms, we are increasingly seeing municipalities and their officials in the legal firing line. But does this approach work? And what's really at stake when law, environment, and governance collide? We are thrilled to have Dr. Melissa Strydom with us to explore these questions and more. Melissa has more than 15 years of varied legal sector experience. She practices in public and regulatory law, including environmental law and related areas. She is currently a legal consultant and consults for Warburton Attorneys Incorporated and other clients, providing wide-ranging legal assistance and advice on commercial, contractual matters and regulatory requirements for different projects. Her experience and interest in compliance and enforcement led to PhD research considering criminal sanctions for environmental law transgressions. She is an honorary research fellow at the University of KwaZulu-Natal School of Law. Melissa, welcome to CLESTalk. We are so honored to have you with us today.
Thank you very much for having me, Ledile.
Just to begin, could you set the scene for us? What is the general context of environmental prosecution, particularly in relation to environmental impact and pollution-related crimes? And what do you see as critical information or knowledge gaps that continue to hinder effective deterrence?
Thank you. Sure, Ledile. So as you know, South Africa has many environmental laws, many of which are promulgated in the late 90s to give effect to the constitutionally protected environmental right. These environmental laws span various subsectors, including biodiversity, heritage, protected ecosystems and areas, water resources, oceans and coastal areas, atmospheric emissions, and waste management. Practicing environmental law and assisting clients in responding to compliance and enforcement action and prosecutions provided insight into the practical vulnerabilities of compliance and enforcement mechanisms. And it's these experiences that led me to a PhD study focused on industrial and related environmental impacts and pollution, thereby limiting the research scope. Because biodiversity-related crimes are quite different from pollution or impact-related crimes. And often there's a lot of, you see a lot of the biodiversity crimes in the media, rhino poaching. And so because I was advising in sort of a corporate commercial compliance context, and those don't always get the same sort of media attention, that was my focus. Generally, biodiversity crimes are committed by individuals and the damage is more immediately apparent, like the poaching of an animal or species. Whereas pollution or impact-related crimes are often committed by businesses or entities or people acting in a business or a commercial of some interest, or as a result of the failures by people where environmental impacts or degradation may not necessarily be immediately apparent. So it could be environmental degradation that doesn't register immediately to the ordinary citizen as problematic. So, for example, clearing a property of vegetation for a development, or progressive air or water pollution. So I considered concluded prosecutions for crimes under the National Environmental Management Act, or NEMA, as we refer to it, the National Water Act, the Air Quality Act, and the Waste Act. Again, also just to limit the research scope. So these laws contain numerous criminal offence and penalty provisions. On conviction, criminal liability may be substantial and far-reaching, including maximum prescribed penalties of up to 5 million rand or 10 million rand, or imprisonment of up to 5 or 10 years, depending on the nature of the offence. NEMA also contains instances where additional criminal liability may be imposed through Section 34. A gap that this research considered was the changed landscape of criminal sanctions over the years, how the criminal sanction is used, that is through concluded prosecutions, and what impact this has had on the regulated community or effective enforcement. There have been significant increases in the penalty amounts in these 4 laws over time, except for the National Water Act, which is obviously topical considering the theme of our discussion today. The National Water Act doesn't stipulate a monetary fine, but refers to time-based penalties of 5 years imprisonment. To convert this to a monetary equivalent, one must refer to the Adjustment of Fines Act and notices under the Magistrates Court Act, which then converts to a monetary equivalent of 200,000 rand, which when you look at the NEMA Equality Act waste offences of 5 million or 10 million, 200,000 rand really pales in comparison. So this is an aspect that the National Water Amendment Bill that was published at the end of 2023 aims to address. But there's still an inconsistency in how criminal sanctions are drafted and enforced across these 4 laws, the NEMA, National Water Act, Air Quality and Waste Act, particularly as they also fall within the mandates of different departments or enforcement agencies. It is also problematic that there's no gradation of these offences based on severity. So in other words, similar penalties are prescribed for serious offences that have direct environmental impacts, but also similar penalties for less serious offences that don't have environmental aspects, such as administrative requirements. This creates, unfortunately, much discretion for enforcers, prosecutors, and magistrates. And such an increased discretion increases the risk of inconsistent enforcement. So my study involved gathering case information for about 53 concluded prosecutions from different sources, including research participants. The conviction rate in the concluded prosecutions considered was high, with only 1 case resulting in an acquittal after going to trial. So I considered cases between 2005 and 2020. Nearly half of these prosecutions were concluded through plea and sentence agreements under Section 105A of the Criminal Procedure Act, which is a particular trend in environmental prosecutions, and especially in municipal prosecutions that we'll get to a little bit later on in our discussion. So, and as I mentioned, my research also gauged view of 32 participants involved in environmental compliance and enforcement, both from the public and private sectors. Some of the challenges highlighted by my research included that because prosecutions generally occur at a magistrate's court and are not reported in a central or academic or research platforms, or such as case law reports, sufficient information regarding concluded cases is not easily accessible or in the public domain, which impacts the deterrent effect and value of successful prosecutions. The most significant challenge in environmental law enforcement through prosecutions is the capacity constraints of role players, including authorities, investigators, prosecutors, and magistrates. And another challenge is the complexity surrounding environmental laws and requirements, and ever-changing legal requirements, evidence collection, and presentation. And then there are the general challenges facing the criminal justice system, not to mention that we already have an overburdened criminal justice system. So based on my extensive analysis of these laws, the cases, and participant views, the study made recommendations to contribute to the more effective use of criminal sanctions through improved legislative design, including that legislators, law drafters, and policymakers could exercise restraint in that laws should not be amended too frequently, should not prescribe high criminal sanctions for every transgression without gradation based on severity. Criminal offences across these laws do not always clearly provide for the elements of fault or culpability, but there aren't clear and convincing indicators for no fault liability. This is also an important point when we get to the discussion of municipalities, municipal managers being held accountable, and the proposed amendments that are on the table that we'll discuss. There's a need for increased enforcement capacity that was expressed by participants, including additional enforcers and additional training. But research participants indicated that excessive law drafting and changes lead to overregulation, which overburdens the regulated community and the enforcement structure. This suggests that more resources should be directed towards practical enforcement rather than legislative drafting capacity and frequent law changes. And a significant issue that I want to highlight, and that I've highlighted on several platforms before, is that knowledge is restricted by the absence of a readily and publicly accessible database containing sufficient information on environmental prosecution case outcomes. Increased knowledge may offer greater deterrent effect, improving the effective use of criminal sanctions and the realization of the constitutionally protected environmental right. It would also enhance legislative drafting to ensure that provisions are practical, accurate, and enforceable, and it would benefit all stakeholders, the public and the environment. So, although I considered 53 concluded prosecutions by the end of the research in 2020, I've obviously, seen quite a number of additional prosecutions that have been reported, including in the DFFE's annually published National Environmental Compliance and Enforcement Reports. And I think my tally is at about 85 cases in total, with a recent emergence of about 8 municipalities being convicted as well. So that sort of indicates some progression over time.
Thank you so much, Melissa. That's an insightful overview. It clearly shows how much complexity lies beneath the surface of this prosecution. Now, next to our question, we have observed an emerging trend of municipalities being prosecuted for environmental offenses. Could you walk us through how this shift came about and what are some examples of successful prosecutions?
I know that it was something the authorities had struggled for a while because, this issue of failing wastewater treatment plants and maladministration by municipalities isn't new. It's something that's that's come over many years. But there was sort of concerns, and I think there's been a CLESTalk on the defenses that municipalities have raised. So it was something that eventually came to a head in about 2020, with I think the first successful prosecution of a municipality in 2022, where the Rand West local municipality was successfully prosecuted. But an interesting trend is that most of these municipal prosecutions have ended in a plea and sentence agreement, so that it hasn't gone to trial. So there are a lot of the principles underpinning those prosecutions that haven't yet been thoroughly tested. So by my tally, I've managed to gather information around 8 successful prosecutions. But, there are reports in the media. So the Daily Maverick published an article on 5 May that says there have been criminal cases that have been opened against 26 municipalities. So the ones that I've obviously considered are the ones that have been concluded. And I'm just going to run you quickly through the list, just mindful of our time constraints. But so there was a State versus Rand West local municipality that was concluded in May 2022. State versus Machabeng local municipality, State versus Dihlabeng, Thaba Chweu, Lekwa, Inruba Yetembe, Governor Mbeki, and Dipaleseng. Many of these sort of straddle issues, either waste-related issues or wastewater treatment plant issues. And, the last 2 cases, Governor Mbeki that was concluded in May 2024 and Dipaleseng in November last year, also concluded through 105A plea and sentence agreements, and there the fines were significant. For Governor Mbeki, it was 200 million rand, and 50 million was suspended for 5 years. But then the fine is specific to say 150 million must be utilized for repairs by a particular cutoff date. And there are 18 specific conditions in the order tied to that penalty as well. And Dipaleseng also 160 million fine, also to be utilized for repairs, again with 19 very specific obligations in the order relating to what needs to be done in order to address the issues.
That's very helpful, Melissa, especially in understanding how we got here. It does raise questions around the challenges. With this development, no doubt come challenges. what kind of legal or practical challenges have arisen from the prosecution of municipalities? Or rather, let me just put it differently to say, what challenges have arisen from this municipal environmental prosecution, and what legal changes have been proposed to address them?
So these prosecutions are really intended to deter and ensure that municipalities comply with their environmental law obligations, particularly considering the dire state of most of our wastewater treatment plants in South Africa, and those stats we find in the Green Drop reports, which are published periodically. And criminal sanctions are a form of holding those responsible to the ultimate account, as it is said to be the state's most condemnatory response to address societal ills. However, as I mentioned earlier, our criminal justice system is severely constrained, and these cases are not easy to prosecute. Moreover, it's in the context of municipalities, it's not individuals being held accountable, but municipal entities. And arguably, any legal costs or fines that are imposed due to mismanagement just filter down to us as the taxpayer. And there's really no real hard consequences for an entity that's successfully prosecuted. The entity doesn't go to jail. The entity doesn't get a criminal record like us as individuals would. So it's ultimately a monetary fine. And in addition, the criminal prosecution addresses a specific contravention at a particular point in time. It cannot address the continuing underlying infrastructure issues. So money can be earmarked in a fine to fix a specific part or malfunctioning plant or machinery that resulted in pollution, but it doesn't address the bigger underlying systemic issues of the plants not being maintained for many decades, not being able to cater for increasing capacity demands, stricter regulatory controls, etc. And it also doesn't cater for the next piece of equipment breaking. So amendments to the National Water Act are proposed to bring its fine provisions in line with the other environmental management acts, as I mentioned earlier, because those fines are quite low compared to the other acts. But another clause in the National Water Amendment Bill provides that municipal managers and corporate directors may also be convicted and potentially sent to prison for water pollution offences committed by the entities they represent. Professor Michael Kidd and I explained in a Daily Maverick article published in April this year what our concerns regarding absolute liability is. So considering our time constraints, I'd rather refer to what we sort of outlined in that article and get to our last 2 points that we want to cover in this session.
That's interesting. The point that you just highlighted was so much interesting. You have laid it out so clearly. Let's now build on that. From your experience, how effective are these environmental prosecution in promoting compliance and improving municipal service delivery? Do they drive reform or simply serve as warning?
I mean, it's a very tricky question to answer because I haven't, and I'm not sure anyone has really sort of qualitatively or quantitatively studied it. But nevertheless, I think it is very important that environmental polluters are held accountable in both the private and public sector. We can't be seen to hold the private sector to a higher standard than the public sector. And I do think the string of successful prosecutions will or should have a deterring effect. In the context of a municipal entity being prosecuted and a plea agreement being concluded, however, I think the deterrent value may arguably be diminished because no individual is being held accountable. But again, no one in the public service, at least, has been sent to jail or fined in their personal capacity yet. It is also not the purpose of criminal law or criminal punishment to make an example of someone, but to punish an offender for an action deserving of punishment and prevent and deter further crime. So in this context, it may be difficult to pin the failures on one person because it is often as a result of decades of poor infrastructure management, lack of maintenance, and decline. But I do think collectively, if there's more awareness that these prosecutions are happening, I think people would think twice before committing environmental offenses.
That's a crucial reflection, and it brings us to a broader question about solutions beyond just the courtroom. To wrap up this session, I just quickly like to ask this last question. Recognizing that prosecution is just one tool, what practical alternative steps could be taken to address or alleviate water and wastewater service delivery challenges?
And I think this is an absolute critical question. and one I can't fully answer in a short time, but I think it is currently top of mind for government agencies, including the Department of Water and Sanitation, even the presidency, and working with local municipal governments and SALGA. And there are numerous experts and work streams within various agencies and several universities and institutions, all focused on addressing this crisis, including the Water Research Commission. There have been several investigations and reports by the Human Rights Commission concerning municipal failures. And there are also several public benefit or NGOs that tackle these issues like WaterCan or even AfriForum. There's also a proposal of ring fencing funds within municipalities for water infrastructure and establishing a public-private partnership regime, which, with amendments to the Treasury regulations, commenced on 1 June, which also establishes a triple P advisory unit to assist and provide support for institutions on applications to register for a project with the relevant Treasury and providing guidance on those aspects. So these amendments aim to streamline procurement approval processes for large projects. But my contribution in this context of legislative developments is simply this, which we also mentioned in the Daily Maverick article. Criminal law and criminal prosecutions are not a silver bullet. I don't think there is a silver bullet. There isn't one simple solution. It is a sort of cross-disciplinary, cross-sectoral, with different organizations, playing different roles. And particularly in this context, the wheels of the criminal justice turn slow. It's already overburdened. And even in the case of these successful municipal prosecutions where funds have been earmarked for repairs, it's like putting a plaster on a gaping wound. The underlying problem is still systemic and complex. So introducing the stick of imprisoning municipal managers through the very broad wording that's proposed in the National Water Amendment Bill is an extreme reaction or disproportionate attempt to overcorrection. So in my mind, society and legislatures tend to react to a problem by introducing the opposite extreme. But the law is not a place for that. The provisions must always be measured and proportionate and be able to catch the offender worthy of commensurate punishment. An absolute liability provision doesn't do that. Aside from these comments, within the current legal regime and based on actual practical concerns I've come across in practice, and where clients and specialists have their hands in their hair, there are simple things that can be addressed, like, for example, intervention is required to remove unnecessary and unreasonable delays by municipalities granting Water Services Act approvals to private sector solutions intended to address urgent pollution problems, which municipalities are incapable of fixing themselves. For example, a private sector participant suggests a water treatment effluent or sourcing solution for a specific development, whether residential or commercial. That may require several different regulatory approvals for this, an environmental authorization and NEMA, a National Water Act water use license, a Water Services Act approval, and these are all from different authorities. So it's quite a cumbersome regulatory process. And although necessary, now, it should be purposely streamlined when it comes to water infrastructure. Practically, it is not my impression that this is the case, based on the type of matters we are asked to advise on and the difficulty such projects face in getting government authorities to meet them halfway. So, for example, in one instance, a municipality was purposely delaying approval under the Water Services Act for a private sector water services solution because it feared losing revenue in circumstances where it had already shown and proven incapable of performing the service. This is just like, it's untenable. And those functionaries within municipalities who do that should be held accountable. And then the second and my last point is just the administrative labyrinth that is the online water use license application system also requires review. Currently, the online submission system requires application forms not just per National Water Act water use, but per coordinate, which for some simple projects results in hundreds of application forms being required, creating a significant administrative burden for developments or water infrastructure solutions instead of a logical and practical approach being applied. This is not about undercutting an approval process, but making it more streamlined and efficient. This is a concern several specialists have raised with me, and it seems like something that could be relatively easy to adjust or fix, where there is someone within the DWS willing to just listen and adapt. And that's sort of the end of my contribution, Delia. I'm sorry, now we've gone a little bit over time.
No worries about that. And that brings us to the end of this deeply thought-provoking episode of CLESTalk, Law for Sustainable Cities. We want to extend our sincere thanks to Dr. Melissa Strydom, for joining us and sharing rich insights into the evolving landscape of environmental prosecution in South Africa, from the complexities of holding municipalities criminally accountable to the limitations of a purely punitive approach. Today's conversation highlighted one essential truth that legal tools alone cannot fix systemic service delivery failures. While prosecution may bring much needed attention to environmental harm, they must be balanced with practical, sustainable, and also well supported alternatives that strengthen capacity and promote compliance, especially at the local government level. To our audiences, please remember to subscribe, follow, like, share, and also interact with us and our special guest on all our various CLES social media platforms. Thank you for listening to CLESTalk, Law for Sustainable Cities, and look out for our next podcast soon.